collecting and distributing money to defrauded investors, and we have a very distinguished panel. I am not going to get into elaborate introductions because I only found out I was going to be the moderator very recently. So we are just going to go in reverse alphabetical order because that enhances fairness. So, time just did those. Ms. Winship, please. All right. So, Verity Winship is going to start us off with some discussion about fair funds.
So, I'm really delighted to be here and to really think about this issue both in the U.S. and Canadian context. But my job today is really to outline how publicly obtained investor compensation emerged in the U.S. And I'll lead up to the adoption of the statutory fair funds provision that allows the SEC to direct monetary money penalties to investors. But I want to step back a little bit first and really think about and place this development in the context of the various remedies available to the securities regulators that also can result in investor compensation. And so I've put up just on the screen here a list of the remedies that I want to briefly address while we're in our time here. So I should note that for a long time in the U.S., there was quite a bit of reluctance to allow securities regulators to focus on compensation at all. SEC Commissioner William Carey, for example, asked whether it made sense for the SEC to be a private collection agency, and he answered with a confident no, not at all. And this is just an annual report from '76, same idea, really seeing this as antithetical to what the aim of the securities regulators was. And this was seen as a job for private litigants in the U.S. system. But even though compensation in some sense was antithetical to the regulatory structure, or at least not seen as an appropriate focus of securities regulation, the SEC did have other mechanisms to direct money to injured investors, even in the early days. And in particular, they were able to request equitable remedies. And within this, they have restitution and disgorgement, and I'll reach a couple others in a minute. There was no explicit grant to the SEC to seek, for example, to seek disgorgement. And in fact, it took a while for this remedy to be adopted, or for the SEC to look for this. It took 30 years before they actually started seeking this in enforcement actions. But it's now well established that the SEC can seek disgorgement in federal court as part of the court's equitable powers, and it can also seek a disgorgement in administrative proceedings. This is statutorily given in the Remedies Act in the 1990s. So what's the relationship to investor compensation? Obviously restitution, that seems obvious. The whole point is that it was intended to make investors whole. Disgorgement, in contrast, is focused on depriving the wrongdoer of unjust enrichment. So the connection to investor compensation is not self-evident. But nonetheless, the SEC has long had an explicit preference for directing disgorgement and disgorged funds to investors. And in fact, before penalties were available for this and became a source of investor compensation, so before the early 2000s in the US, the Commission followed a policy of allocating money first to disgorgement, which could be given to injured investors, and then only secondarily to monetary penalties or to money penalties, which could not be distributed. And so the disgorgement amounts themselves could be quite significant. This is just an example. Michael Milken paid $47 million in disgorgement, and you see some high disgorgement amounts even after some of the penalty authority comes into play. We also have some sense of the magnitude overall as well. Sarbanes-Oxley required the SEC to do many reports, and one of the reports was about this compensatory function. And so in this self-study, the SEC looked at disgorgement between 1997 and 2002, and found that more than $1 billion was distributed to injured investors through disgorgement funds. Okay, so this is before fair funds ever comes into effect. And these funds were created in court or in administrative proceedings. We have some numbers. There may be some issues with the statistics, but I leave that to Urska to handle later in the panel. But this gives us a general sense that this was a main mechanism at the time for distribution. Okay. So I said these were equitable remedies. I've put up the statutory provision allowing this broad category of remedies in court proceedings. Receiverships and asset freezes are also folded into this grant of equitable remedy powers, or the power to seek equitable remedies. It is not an explicit grant, but court opinions have concluded that the SEC has the power to request a receivership or asset freeze, and that courts have the power to grant this. So it's a well-established piece of the SEC's arsenal. The showing on the asset freezes. So we heard a little bit about this in our opening and keynote speaker. The asset freezes in the U.S. Can be obtained on a lower showing than preliminary injunction. And so the SEC has to show that there's a threat that the defendant will dissipate the assets or take them out of the country, and some basis for securities violations. They can also be sought after, from relief defendants who themselves are not wrongdoers, but who may have the products of another's wrongdoing. And here they just have to show that it's a product of wrongdoing and that the relief defendant does not have a legitimate claim to the funds. This chart is some data that Urska has developed and may speak about later. This just shows the numbers of asset freezes, so the number per year of asset freezes. And you can see the spikes are probably where you would expect them to be after the financial crisis. So you see a spike in 2002 and 2014. It tells us about asset freezes. There's not good data that I've seen, although I'm willing, if you have it, let me know. But I have not seen good data about receiverships and the number of receiverships, the SEC requested receiverships. In part, they're not included in SEC financials because any money gathered is seen as money gathered by third parties and not by the SEC. But we do have this data on asset freezes, which are often followed by a receivership requested by the agency. And we can see examples of where this comes up, matters that lead to receiverships. We have Ponzi schemes, which you might expect. Securities offering cases would be another example of an area where you see this structure being set up. Now, the last piece of this puzzle that I want to set up before we move to the other panelists is about money penalties. And so these also did not start out with a clear relationship to investor compensation. On the slide, I just put a piece from the 70s where they're looking at the use of money penalties by agencies, and it really is viewed as, by definition, unrelated to investor compensation. And the SEC only got broad power to obtain money penalties fairly recently in the 1990s. First in insider trading and different pockets of powers, but really broad money penalty power in the Remedies Act in the 1990s. this has, at the time, the money could only go to the U.S. Treasury. It didn't go to funding the agency, it didn't go to injured investors, it could only be directed to the U.S. Treasury in general. This has since changed, and it changed in Sarbanes-Oxley, so here we come to the fair funds provision, where the securities regulators were given a choice. They could still direct money to the U.S. Treasury, but they had the option of directing it to injured investors as well. More recently, we have Dodd-Frank, which adds a third option, which is the Investor Protection Fund. So the SEC Investor Protection Fund, which is directed in part to whistleblowers, which we'll talk to bounties for whistleblowers, which I think we'll talk about later in the day. I want to leave you with this, which is the fair funds provision. This is the statutory provision that gives the SEC the option to direct these penalties to injured investors. This is our current version. As it was first adopted, it actually allowed the SEC to add money gathered as money penalties to existing disgorgement funds. So for a while, you see a little bit of a distortion. You can only create a fair fund where disgorgement would be appropriate, or you see settlements where there's $1 in disgorgement and huge money penalties, multi-million-dollar money penalties. Dodd-Frank took care of that, and this is the version we have in effect in the U.S. now. And with that, I'm going to turn it over. Oh, and actually, last word on this is we've changed attitudes. And so we see, if you look at the annual reports now, we see the SEC really enabled and listing this distribution to harmed investors as part of their mission. We also see, this is just an example of a court case where a judge actually conditions approval of a settlement in part on the distribution, or at least the setting up of distribution to injured investors.
Thank you, Barry.
Thank you.
Urska is now going to share a bit of the experience with the fair funds provision.
Thank you. My name is Urska Velikonja, and I'm very pleased to be here to talk to you a little bit about some of the research I did about the SEC's fair fund distributions. As Verity mentioned, the SEC can compensate injured investors through a variety of different schemes. One of them is through receiverships, and that there's about 40 or so per year that the SEC itself sets up. There's receivership set up in criminal cases. The CFTC likewise has the authority to set up a receivership. In addition, the SEC also has the power to compensate investors through what they call a disgorgement fund, where only the disgorged assets are put into a fund and then paid out to investors, either in an SEC overseen fund or by a settlement where the defendant will agree, okay, as part of the settlement, we agree to pay out, to compensate injured investors to the extent that agreed in the settlements. What I studied were the SEC's fair funds. Those are funds set up by the SEC that include both disgorgement and monetary penalties. So the information I'll present now will focus on that subset of funds. That's not the universal funds that the SEC will set up to compensate injured investors. Now, by definition, when can the SEC set up a fund? It can only set up a fund where it's actually able to collect the penalties that it ordered against the defendant. The SEC's collection rates, as Adam mentioned earlier, are around 50% with some variation. And of those funds that are in fact collected, I was able to estimate that about well more than half end up being distributed through a variety of funds, including these fair fund provisions. So let me give you a little bit of an overview of the SEC's fair funds. I do apologize for the size of the slides, but this gives you an idea about the sorts of fair funds that the SEC has set up since the provision was adopted in 2002 until the end of 2013. So the SEC has set up 243 fair funds in a variety of different cases. The total amount set aside for distribution is $14.5 billion, which is quite large. The average fund is about $60 million. The median fund is smaller, about $16 million for a median fund. And how do those compare to class action settlements? For that period, they're quite similar. So fair funds and class action settlements end up being relatively similar in these central tendencies. Relatively average size is about the same, as well as the median size of the fund is about the same. Now they vary considerably. You see that the largest fair fund was created in the accounting fraud case against AIG. It was more than $800 million. The smallest one was in an insider trading case where $25,000 was set aside for a distribution. Now, I started out by saying that the SEC doesn't return all of the collected funds to injured investors. So I spoke to someone who works at the Office of Distributions at the SEC. How does the SEC go about deciding whether to create a distribution fund or whether to not create it and just remit those penalties to the U.S. Treasury? So what I heard was that there's various factors. The most significant factors are not going to be surprising, right? The first one is, are there in fact identifiable victims with identifiable harms, right? Is it even possible to find people to compensate? And secondly, the cost, how much is it going to cost to compensate these investors, and what's the size of the fund? Are the costs of the distribution going to eat up the entire fund, or is there going to be enough left over for investors to compensate? So we end up looking over these various fair funds the SEC has created, that it's a lot easier to do a distribution where settlements are large, where there's an easy way to identify the victims. So in accounting fraud cases where there's usually a class action settlement in addition to a fair fund distribution, what the SEC will do is we'll take the pot of money and put it in the class action account and distribute pursuant to the same process. That makes it easier for the SEC to identify investors. Secondly, the second group that's relatively easy to compensate are cases brought against investment advisors and broker-dealers. Oftentimes, broker-dealers and investment registered entities don't actually know who to compensate, right? They have a list of their customers, they have a list of transactions. It's a lot easier for the defendant, just as Vice Chair Kowal mentioned earlier, for the defendant to identify who it is that should be compensated. It's a lot harder to do in cases where it's more difficult to identify the victims. So those turn out to be insider trading cases as well as market manipulation cases. In those cases, you see that the funds are relatively rarely created and tend to be small, and there are just fewer. It's a lot harder to achieve investor compensation in those types of funds. Okay, so let me give you a bit of an overview in how the SEC has created these funds over time. Why are there great questions? So the overview, the blue is the amount set aside into a fair fund, and the red line is showing you the number of funds created. There's some variation over time. On average, there's about 20 fair funds created. That would be in addition to disgorgement funds and receiverships. And the money set aside is anywhere between about $500 million to almost $3 billion in 2004. Now that turns out to be relatively similar to class action settlements. Class action settlements are slightly later. They're often used in accounting fraud cases, at least. The class action will settle after the securities enforcement action is settled, and as a result, we see a little bit of a lag in these cases. There's a considerable degree of overlap. With the SEC fair funds, you also see a considerable dip in 2009, 2010. You might see is the SEC stepping away from investor compensation. The best explanation for that is, in fact, that the SEC ramped up enforcement against Ponzi schemers and offering frauds, what Verity mentioned. And those cases would not be included in my study. There, the funds were collected and distributed pursuant to receiverships. Okay, so what sorts of cases are these fair funds created? So the Securities and Exchange Commission, like the OSC, has the authority to bring cases in for a variety of different securities violations. You have cases against issuer reporting and disclosure. Those would be your accounting fraud cases. That's 29% of fair funds are created in accounting fraud cases. Another large category is cases against investment advisors. A lot of those are market timing. And you have cases for broker-dealers for charging fees that they didn't properly disclose, insider trading, and so forth. In contrast, this is class action settlements over the same period of time. You see that about 60% of cases in class action settlements are in accounting fraud cases. That's compared to about the amount of the distribution. So in terms of amounts distributed or set aside for distribution in fair funds, about 44% are in accounting fraud cases, and the remainder are in all these other cases. Compare that with class action settlements, and you see that about 90% of dollars security class action settlements are paid out in accounting fraud class actions. So what these numbers suggest to us that there's a bit of a, the SEC and private plaintiffs do not target the same types of cases, which will tell us maybe there's some value to setting up public compensation scheme in addition to the availability of private litigation. Okay? So we see the SEC targets different misconduct. What they also do is this, the SEC targets different misconduct. They also target different defendants. So Adam mentioned this earlier, that in securities class action, private litigation, generally in the United States, individuals don't end up paying. They may often be targeted, they don't end up paying out of pocket. So the numbers I was able to find in class actions, individuals were targeting 6% of class actions. They ended up paying in 6% of class actions, and they pay less than 1% in the aggregate. In these SEC fair funds in the amount, individuals pay something in 60% of fair funds, and the total contribution by individuals and other third-party defendants, here I'm talking about auditors, investment banks, and so forth, is on average about 13.5% of the total. The rest comes from the issuers and companies that are targeted. And these figures will vary considerably by the type of action. In accounting fraud cases, fair funds, individuals and third-party defendants pay almost 20% of the total amount distributed. In insider trading, it's 37%. Market manipulation, it's 65%. In other cases, it ends up being a little bit less. Okay. So another thing I want to talk about is that in a lot of these cases, you mentioned that there's been this disagreement in Canada about precluding private litigation when the Securities Commission has gone out and compensated investors. How does this work in the United States, and what does this data tell us? So what this tells us, this is an overview of outcomes in parallel private litigation. So what I did is I looked at cases in which a fair fund was created, and looked at, was there a securities class action or some sort of private litigation that was filed afterwards, or that was also paid out some settlements. So what we see here is that there's really two types of securities cases out there in terms of parallel litigation. There are accounting fraud cases, which are listed at the bottom, where in all cases where there was a fair fund distribution, there was also a parallel class action. And a lot of those cases ended up to a successful monetary settlement. And if you look at the total amounts paid out in those cases, how much came from public compensation, how much came from private compensation schemes, you see that the vast majority comes from the private compensation scheme. That's not true for other cases, right? I mentioned that 100% of accounting fraud fair funds are accompanied by a parallel class action. For the other cases, broker-dealer, investment advisor, insider trading, half of the cases are accompanied by private litigation. Of those half, in 91% of accounting fraud cases, there is a parallel monetary settlement parallel to the fair fund. In other cases, this is it, there's only 29% of cases where there's a fair fund distribution. In 29% of those cases, there's also some payment coming from a class action settlement. And finally, in terms of recoveries, I mentioned in the accounting fraud cases, about 15% of the recoveries in cases where a fair fund was set up. So 50% of the recoveries came from a fair fund. 85% of recoveries came from class action settlements. In other cases, I give you an example of the broker-dealers, which is somewhat representative of these other cases. 22% of total compensation comes from class action, and 78% comes from a fair fund distribution. So in sum, the SEC will often compensate, at least in these fair funds, where private litigation is either unavailable or just doesn't work for a variety of reasons. And so, public compensation schemes can work as a good supplement. They can go supplement because they target different types of misconduct, and they also target different defendants. Defendants who in class actions just don't end up paying. Finally, this is something I didn't address a lot in this talk, I do talk about this in the paper, is that there have been criticism over the years of how the SEC had exercised its authority to set up and administer these fair funds. And it has been able to respond to criticism over the years, both in terms of how it was managing the funds and in what sorts of cases it created a fair fund. We don't see the same sort of liberal responses from private plaintiffs in class action.
So Jean-Francois is going to give us an insider's perspective on the role of provincial securities regulators in providing compensation to investors.
Thank you, Adam. Good morning, everyone. Thank you for the invite. Thank you, Fair Canada, for inviting us today. As Director of Enforcement of the Quebec AMF, I will talk about the practicality of trying to recover money for investors and how we try to facilitate this recovery for investors. Obviously, investor protection is at the heart of our mission as securities regulator, and Monica, you underlined that in the comment this morning. We put a lot of effort in investor protection in trying to detect and prevent and more quickly potential harm to investors, but obviously it is not always possible, and most of times we intervene once a loss has already been suffered. So we have a lot of tools that are at our disposal, and we try to put forward these conservatory measures like freeze orders and also other administrative and penal, quasi-criminal sanctions, but these are aimed towards the author of the misconduct to have a deterrent effect to prevent future harm to investors. And in saying that, we recognize that in terms of investor recovery, it is very important, and we have not done enough in the past years to be able to recover money and to put this money back in the hands of investors. In Quebec, we have two principal recourses that may be exercised by the regulator. The first one is a civil action under Section 269.2 of the Act, and the AMF, so the regulator may apply to the court to obtain a declaration to the effect that a person has committed an offense, and that person be condemned to pay damages to the investors who suffered the loss. Up to now, there is no precedent in Quebec of the exercise of this recourse leading to a final judgment. So why is that? There are three main reasons. The first one was historically probably the lack of resources. In the recent years, at least in Quebec, we put a lot of new resources in terms of people. We tripled our resources in our enforcement team. But in the past, before that, we had to favor the exercise of conservatory measures to put an end to illegal activities. And we also focused on protection of investors and privileged quasi-criminal recourses in order to have, we believe, a more immediate and deterrent effect on wrongdoers. The second reason, and it's been discussed this morning, and I think it's probably the most important reason, is that we have, when we exercise recovery recourses, we have poor chances of successful execution of judgment against defendants. When we talk about investor recovery, the ultimate goal is to actually recover money and to give this money back to investors. So we must avoid situation where we institute civil legal proceedings that last for years, and if the end result is that no money is being recovered and put back to investors. So most of the damaging activities which could give rise to civil action relate to illegal distributions of securities. And this conduct are most of times perpetrated by non-market participants who often are already or will become insolvent when we exercise our recourses. So in the context of fraudulent activities, the assets will be gone before we're able to freeze them, and any successful civil judgment could not be executed. And again, it's been also discussed just at the end of the first panel about our capacity to recover sanctions. I think in Quebec, the level of recovery of administrative penalty is close to, or a little bit more than 40%. And when we talk about quasi-criminal proceedings, it's less than 10%. So if we consider this, and most of, again, when we talk about Ponzi schemes, illegal activity schemes, we're talking about non-market participants, and we go most of the times in quasi-criminal recourses, and our capacity to obtain money from those recourses is really low. The third reason I think is relating to the burden of proof in the execution of those recourses. And when we put forward a civil action, we have to establish a causal link between the alleged fault and the damage suffered. And this burden of proof requires that we establish that each single investor relied on the alleged illegal misconduct before investing. So this is a very important burden related to each individual, which is very difficult to discharge. And obviously, it requires the cooperation of the investors, and in many instances for different reasons. Some investors are reluctant to cooperate with the regulators, and some of that may be explained with concurrent exercise of class actions. Just as a note, because I'm supposed to cover all Canadian jurisdictions, obviously, my comments are based on our experience. We had some discussions with our regulators in Canada, and it's the same conclusion. So they have the same powers, but there's no case law precedent where those recourses have been successfully used in Canada. The other one is an administrative sanction that we can obtain from our administrative tribunal. So just so that people know that in Quebec there's a slight difference. We have an external independent tribunal, but it's the equivalent of the commission. So we can seek a request, a recourse in front of this administrative tribunal to order a rescinding of any transaction and directing the person to repay the security holder any part of the money paid by the security holder. So here the challenge is different, but it's still important. We have to be able to establish the link with the money and the investor. So the issue of the tracing of the money is really, really difficult, because once the money has been deposited in the bank account of the alleged wrongdoer, it is pooled into the bank account, and it is almost impossible to trace. And our administrative tribunal, up to now, systematically invokes its lack of jurisdiction to allocate the property of sum of money and decide on the distribution or liquidation of assets. So that forces us, as it is the case, I think, in some of the jurisdictions in Canada, to go in front of our common tribunal, being the Superior Court in Quebec, to request a proper distribution of the assets and of the money to the investors. We just talked about a little bit about disgorgement. We also have disgorgement. It's available to us, but it's true that the primary purpose of disgorgement is not to compensate investors. So again, it's a difficulty for us to obtain those orders. And when we get them, the money that we obtain goes to our educational funds. It doesn't go to the investors. That being said, I don't want to be too pessimistic about this, because we're trying to find ways to put money back to investors, and we have been able to achieve that in recent years, despite the hurdles that I just described. It's still an ongoing file, an important file that we have in Quebec called Fer de Lance, where we've been able to freeze $3.1 million in Quebec, and with the assistance of the OSC, where they were able to freeze $2.4 million. So we froze together $5.5 million. And the money frozen in Ontario was sent back to Quebec. We thereafter filed a petition to the Superior Court in Quebec, requesting the court to liquidate the proceeds of the distribution and to order the distribution of the money to the investors. This recourse is still pending, but upon a positive result, we will then go back in front of our bureau to obtain a lift of the freeze orders so that the money can go back to the investors. And the good news in that case is that I don't have the exact figure, but I think we were able to freeze close to 80% of the money that was raised by the fraudster, but the illegal distribution. The other good approach as well, I think, and Monica, you also talked about that this morning, about settlement. Settlement is a good way also to obtain recovery for investor, because it can be part of the negotiation with the other party. And in a recent case, we've been able to negotiate a settlement with the objective that the investor recovered their loss. And the particularity here is that we were in a quasi-criminal case. We were in front of Quebec court. The people pleaded guilty, and at the sanction phase, we postponed the argument on the sanction phase, leaving the defendant party the opportunity to reimburse the victims in the period of 1 year. If they don't do that, after that, I mean, if they do it, it's good news, and we won't insist on a jail sentence. And to the contrary, if they have not been able to reimburse investors, we will insist on a jail sentence, which is, I believe, quite a persuasive tool that we have. So we try to be creative so that we can be in a position that investors obtain their money. And as was outlined this morning, the OSC, at least in the TD case, also in the context of the settlement, insisted on the fact that money was going back to investors, part of the settlement. The final items, we have an industry-funded compensation fund in Quebec, where the victims of fraud, of misappropriation of sums may be compensated. It's available to investors who have suffered damages as a result of fraudulent actions committed by market intermediaries who have contributed to the fund. And I don't want to get into the details, but I think it's part of the discussion this afternoon, and we have someone from Quebec, Louise Grossier, who will talk about this, but it's an important tool, and I think we have discussion now. At least we made the recommendation at the AMF that the fund can have a broader application in other instances. Last thing that has also been pointed this morning is about our capacity to appoint receivership. I think with our capacity to obtain freeze orders and have a receiver appointed is a very, very powerful tool. The issue here is to be able to use that before the money is gone. So that's about it.
Thank you, Jean-Francois. So we have time for some questions, and you're hopefully submitting some to our question receiver here, which is super charged. But I'll start things off, because I always have questions. So, Jean-Francois, we talked a little bit about class actions. In the U.S. context, the SEC always disclaims the existence of a class action as a factor in deciding whether or not they should bring an enforcement action. But given that you have goals of both promoting deterrence of fraud and seeking compensation, does that factor into your enforcement decisions, because you have limited resources, whether you think a class action is likely to arise out of the misconduct?
I don't think it would be an important factor in the decision to, I mean, I think at the end of the day, it will all depend on what we've been able to achieve in the context of the investigation. If further to the investigation we were able to collect the evidence that would support a recourse, we would continue proceedings, I think. And for us, and we have a variety of possibilities. As regulators, at least in Canada, we have the potential administrative route, and we have the quasi-criminal route. And now Monica also told this morning that we have close relationship and team, investigation team with police organizations or law enforcement agencies, where we can conduct criminal investigation and criminal proceedings. So I think the most important thing for us is to see what we can get in terms of evidence, and based on that evidence, if we can take the criminal or quasi-criminal route, I think we achieve a very important deterrent effect. And so I think my answer to your question would be no, we would not really, it wouldn't be an important factor for us to decide if we pursue or not our proceedings.
So I'll reframe the question for Verity and Urska. The SEC disclaims any influence on its choice of enforcement proceedings, but do we see any evidence that the availability of the fair funds provision for starting in 2002, that it has affected the SEC's enforcement decisions?
So, I'm not sure I know the answer to that question, whether it's in fact affected enforcement targets. So I can try to answer a separate but related question, which is how, in cases where the SEC sets up a distribution fund, do we see any impact on parallel class action litigation, right? Does it deter private litigation? So sort of flipping your question and answering the mirror image question. And the general answer here would be no, except for a small subset of cases, and those are market timing class actions. So in the market timing cases. So in market timing cases, these were brought in 2004 to 2006, give or take. The SEC moved fairly quickly and early and settled those cases for very large amounts of money. I think in the aggregate it was $3 billion or something along those lines. Those cases then had parallel class actions that were filed, and class action settlements in those cases were very small because they were taking into account the fact that investors had already received compensation from a parallel fair fund distribution. We don't really see that sort of effect in accounting fraud cases where the fair fund contribution is relatively small.
I also will answer a slightly different embedded question.
Find a better question.
No, it's a good question, but it's a hard question. Yeah, it's not an answer. About the balance between the public and private actions. And one of the concerns when fair funds came about was that it was going to serve as an excuse to cut back on private actions. And so it wasn't clear where people fell if they were concerned about investor recovery and compensation. It wasn't clear where they were going to fall on this issue because this was used as part of the rhetoric to say we don't actually need private actions here because we've now given this tool to our regulators, to our underfunded, but our regulators. And so I just wanted to flag that because I think it sometimes gets lost in the story of this set of tools.
So do we have some questions from the audience to speak?
As we get to that, can I just jump in for a second? One thing about the context, I know she's still finding the good ones. One issue that has come up is this description of settlement and settlement practices. And I wanted to flag this because my sense is that the US context is very different on this. That for a long time we thought of this as 90% of these were settled actions. I've heard lower numbers more recently as the penalties are ratcheted up. I've heard 70 to 80. Urska may have this specific figure, but in our environment in the US, we're really talking about funds created through settlement primarily.
And that's true for these fair funds. Virtually all of these were created in what was a settlement. So there was a settlement, they agreed on the amount, and then that amount was then set aside into a fair fund. Some settlements, in fact, are what I call in the paper that I wrote based on this, is direct settlements. In the settlement document itself will say, this is the disgorgement, this is the penalty, the defendant agrees to set up a distribution fund, these are the investors that are going to be compensated pursuant to distribution fund, and this is how the defendant is going to do it. In other cases, the SEC secures a settlement and then takes that money and has to send out notices, appoint a distribution consultant, figure out a plan. It becomes much more complicated. But at least what I've seen is more recently, to the extent that the enforcement staff can sort of, as they're settling enforcement action, they can predict this is going to be a large enough cost that we want to do a distribution. They'll already identify the potential investors who would receive payments from the distribution fund as part of the settlement of the enforcement action. But a very small chunk of these are contested actions where the court or the administrative law judge will come out and say, okay, this is the amount, and then as a separate step, will the SEC go ahead and set up a fund? That's sort of the exception rather than.
All right, so I have some questions from the audience. Jean-Francois, you'll have to take a stab at this one. In Canada, when disgorgement money is collected, who gets to keep it, especially in IROC settlements?
I don't know for IRA, but for us, it goes to the commission, it goes to the regulator, and we put it back to the education fund. So it goes back to the regulator. I don't know for IRA, I don't know if someone knows about this.
So this is one thing that I've heard from people who worked at the commission, or used to work at the commission, about the compensating investors. So if the SEC does not go ahead and set up a distribution fund, those funds will be paid to the U.S. Treasury. And this has been one of the arguments that the SEC has put forward in favor of setting up distribution funds, because, well, otherwise it just goes to the Treasury. We don't want to send money to the Treasury. We don't get to keep it, but we don't want the Treasury to get it. Therefore, to the extent possible, a distribution fund will be created.
Must make Congress very happy.
I don't know.
Keep the money away from
Payback.
So this is for Urska. The question is, has the SEC reacted to the results of your study? And a follow-on, what changes in terms of rulemaking and enforcement do you think would flow from your study's findings?
So, my experience with the SEC has been that I haven't received much reaction generally to my papers, which is not surprising. They're a huge agency. Why would they respond to findings by one individual academic? Though I have looked at some of the enforcement actions that were settled after when I completed my study, and these fair funds do keep popping up. They do keep appearing in enforcement actions, which one could read as the commission being encouraged by the fact that this is something that they should keep doing it, or maybe I'm just flattering myself. The second question was in terms of rulemaking, whether there should be any rules that are changed. Is that am I understanding correctly?
Rulemaking, or maybe Congress needs to do something.
So in the United States, Congress doesn't tend to do much, not to be too critical. So in terms of this, it's not that I'm not really sure anything ought to be changed. I mean, my takeaway from the study that I did was that the SEC actually does a pretty good job at setting up and managing these distribution funds, and particularly, say, funds created after 2010, when the SEC actually developed some expertise in-house and figured out how to set up these funds and how to then collaborate with outside distribution fund managers, plan consultants, and so forth. So I don't really see need for additional rulemaking.
Jean-Francois, I've got another question for you, which is relates to how do regulators conduct audits to determine whether investment companies and their advisors are meeting their legal requirements to deal with their customers in good faith?
I mean, it's part of our inspection review that we do. I mean, so it's for advisor. Is it for broker dealer or
Investment, well.
Because it's part, yeah, but I mean, part of it is under
Broker dealers and
IRA.
investment
Yeah,
advisors.
but part of it is under IRA's responsibility, but it's part of our supervisory and inspection plan that we do. And like Monica said, there's a new discussion about the best interest obligation now. It's under discussion. There was no decision that has been, and I'm not part of those discussions directly, but we have discussion about this new, or is it already part of the fiduciary duty, or it would add a burden on advisors to have this duty to act in the best interest of the clients. And obviously, if it's been adopted, it will also be part of the inspection revision that we will conduct on the financial advisors.
So here's one for Verity. The SEC got increased civil penalty authority for use in its administrative proceedings as part of Dodd-Frank in 2010, and the Wall Street Journal has been highlighting something of a shift to administrative proceedings in the SEC's actions. Do you see any changes in this in fair funds or the SEC's use of fair funds in administrative proceedings?
So my sense is that this has been very much in the headlines in the U.S. The shift, or at least reported shift to administrative proceedings. I think Urska has found that this might not be a very nuanced version of this. My sense is that it won't make that much difference to the fair funds piece of this, but I wonder if the data shows anything different.
So this is not from the data, this is from speaking with insiders and the person I mentioned who works in the SEC Office of Distributions. And what she told me is that the choice where the case is litigated doesn't have an impact on whether the commission moves to create a fair fund distribution. But what I was told is that the administratively administered funds tend to proceed more quickly. Tend to proceed more quickly than do the court-administered funds for a variety of reasons. Or because of the opposite. No, I believe it's the opposite because of the administrative proceeded could create fair funds. The commission has to act to do something with the fair fund rather than go into a court and having the judge make that decision.
Jean-Francois, one more question on the relationship between your authority and the criminal authorities, right? So how is it that criminal proceedings are initiated, and is compensation to investors, how does that sort out when you let the criminal authorities proceed first?
I mean, I'm not sure that we, unfortunately, it gives us anything with recovery for investors. But the way we work in Quebec, and I think it's probably the same here, is that we, I mean, most of the cases, first of all, come from the regulator because we conduct surveillance and most of the complaints will come to the regulator. So the way we work now is that we have put together a governance structure where we sit together with law enforcement agencies on a regular basis, and we will discuss potential criminal cases. So what we mean is that many cases could be at the same time a Securities Act violation and a criminal code breach as well. So we will have discussion about do we want to conduct this investigation criminally, and if so, we have two options in terms of integrated teams to conduct criminal investigations, and on those integrated teams we have people from the AMF part of the criminal team or the law enforcement agency. So at one point in time we make a decision together for a referral to those teams, and that once we've made that decision, the investigation will be conducted on criminal basis, and that means that we won't do any administrative investigation and recourse. But that doesn't mean that if prior to that we've, for example, been able to freeze assets, so we will maintain the freeze of those assets, and at the end of the process we may be able to put money back to investors. But obviously the main recourse, the criminal recourse, is not towards investor recovery, is to get criminal recourse against fraudster in that case, because we're talking about criminal breaches.
Excellent. So I want to thank the participants on the panel. I want to thank you for your attention all morning. I believe the schedule says you are now entitled to a break, but a short break, because we will start again at 11:15. You join me in thanking the panel.